We all know that family law cases can be complicated, which is why you and your client deserve reliable, hassle-free drug and alcohol testing services. From hair testing to abstinence monitoring, we can help. Visit lextalks.co.uk for more information.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Family Lawyer podcast. Today we have a previous guest of the podcast actually on, Jude Eyre, an Associate Director at the Nuffield Family Justice Observatory, not gazing into space, but gazing into the toolkit that has been published by Sir Andrew Macfarlane around children cases and responding to that and thinking about the impact that it has on the profession as well. So thanks so much for joining, Jude.
Thank you very much for having me, David. I'm really pleased to be back.
For those of you who haven't heard the first podcast that Jude did with us, perhaps in the first instance, Jude, you could just give us a bit of an insight into your work, please, at the Nuffield Family Justice Observatory.
The Nuffield Family Justice Observatory, or NFJO for short, is part of the Nuffield Foundation, which is an independent charitable foundation that largely funds research with the aim of improving social well-being. And it set up the observatory about 6 years ago with the express aim of being a bit of a bridge between the research that it commissioned for many years on family justice and the family justice system on the ground. So the children and families involved in the family justice system, and crucially the practitioners who work with them day in, day out. So that's what we try and do. We do research, we commission research, we undertake research ourselves. We spend a lot of time talking to lawyers, judges, social workers, charities and families, adults and children, about the family justice system and about our research, about what they're experiencing and what they think our research might mean in their context. And then crucially, we try and use that learning from those conversations and from the research evidence to think about how we can support new ways of working and innovation. And I think feeding into the President's Toolkit for judges and writing to children is sort of a key example of that, really. It's about how you might use some learning from research about what might make a difference for children and turn it into something that can actually be used day to day on the ground to help the practitioners who work with them.
And a huge amount of your work is around children, isn't it?
Yes, so our focus as an observatory is on children cases, really, so private law proceedings and public law proceedings. The toolkit spans both of those. It's addressed to any Children Act case or other cases involving the central consideration around children's welfare, and that's our priority area.
So the toolkit we're referencing is Sir Andrew Macfarlane's guidance to family judges on how, what, why, and when to write to children in family court proceedings. Can you kind of elaborate on that? What is it, and why is now the right time to have launched this?
Absolutely. So the President launched this at the end of February, and it's a guide published by him in partnership with the Family Justice Young People's Board. The aim of the guide really is to support judges in writing to children in their cases, as I've said, whether that's in private law or in public law. The guide sets out a very brief headline summary of what the research tells us about what children need for proceedings to work well for them, crucially why writing to children might be of benefit. It talks about the different purposes that writing letters to children might have. And then it also goes on to give really practical detail and examples of some of the language judges could use or some of the structures they could use, some top tips, some things they might want to think about. And I think it's important to understand how this toolkit was developed because, as I've already said, it's published. On the front, you'll see the logos of the President's Office and the Family Justice Young People's Board side by side together. So that partnership between the judiciary and young people is really central to how it was developed. So there were groups of judges involved in discussing what they do in practice, what they have learned works well for them, what they find challenging, young people expressing their own feelings about proceedings, what they found worked for them, what they found didn't work for them, and also a whole range of practitioners, solicitors, barristers, social workers, psychologists, communications experts, researchers, adults with lived experience of the family justice system through Kafka's Family Forum. A whole range of different people have fed in to really try and make this toolkit as informed but also crucially useful as possible. You know, it's not meant to be a lengthy research document that sits on someone's shelf gathering dust. It is meant to be something that can really help practitioners in the day-to-day business of the court, which in Children Act cases, of course, is promoting the welfare of the child.
I've done a number of podcasts in recent months about the language of the law, and there is this real focus on changing the narrative, particularly around family proceedings, changing the words that we use, changing the intonation. This is another example, presumably, of that drive towards modernizing, for want of a better word, the language of law.
I think there's a very practical, obvious reality here, which is if you are a judge writing a letter to a child, then you need to think about what language that child is going to understand. But as you've said, David, I think that conversation about how we make the language of the family courts accessible to all the people who are using them, the adults as well as the children, is a really important one. And how we ensure that the language we use conveys what we want families to understand about what we think is important. In the context of judges writing to children, doing that in a way that's compassionate, in a way that's empathetic, in a way that doesn't default to the kind of jargon which, when you work in court every day, as I have done previously as a barrister, it is so easy to forget what words, position statement, for example, how that is a standard thing that you talk about all the time. And yet even the word position was flagged in the toolkit discussions by some of the communications experts as being a word that has lots of different meanings in lots of different contexts. And therefore you shouldn't assume that if you use it in a letter to a child, that they will automatically know which context you are picking it from. And I think that's valuable learning when you're thinking about making it accessible to children. But I also think it's really valuable learning when you're thinking about making things accessible to adults. So we've seen a number of judgments in recent years where judges have either written judgments to children directly or where they've published an anonymised version of a letter that they've sent to a child as part of that judgment. And we've also seen some really good judgments where judges have done a short form of the judgment at the beginning of the judgment in plain language for the adults involved in the case, whether that's because the adults involved in the case had particular learning needs or had English as an additional language and they felt that would be a particular benefit for them, or frankly, just in recognition of the fact that the language of the legislation, the language of the case law, some of the things that judges need to talk about and think about within their judgments are quite complex, and the sort of legalese that we might use as shorthand to ensure that these judgments don't, span any longer than they need to, might serve that function well. It might communicate well between the judge and the lawyers, and if needed, the Court of Appeal, but it doesn't necessarily make it accessible for those who the case is about, for the family. And never is that more important than when you're thinking about the children at the heart of this and their ability to just understand the very basics of what decision has been made about my life and why.
There's a definite sort of wood for the trees scenario here, isn't there? That we, as you say, there's legalese, there's lots of abbreviations and acronyms that we use, and as you say, they're just assumed. We don't always think about, is this really understood? Are we really explaining this to a lay person, I suppose? And there's almost a comparison here. Listeners will be aware that we have the Today's Conveyancer podcast, the Today's Wills and Probate podcast, and I always think there are lots and lots of comparisons between those areas of law where there's a massive education piece for people who are being introduced to these concepts, often for the first and only time in their lives.
Absolutely. And I think the idea that thinking carefully about how you might describe these concepts to a child, it can actually be really helpful in terms of making sure that the adults who are going to live with this arrangement as well fully understand what was decided and why is really important. So I think that was one of the reasonings behind the power of letters, and the toolkit sets out a range of different purposes that those letters can fulfill. But one of them was about giving children, access to something to go back to, so that even if somebody has told them at that moment in time in their life what's been decided and sort of brief why they think the judge decided that, the person often doing that might be a parent. In private law proceedings, definitely the most likely scenario. And we know from research with parents that they often don't say that they really understand what was decided and why, that some of it is a mystery to them. It's a very stressful situation, even when those things have been very carefully explained to them by their lawyers. Their ability to take that information on at that point in time can be really limited. So if they've got a child asking detailed questions about it a couple of years later, then that can be really challenging for them to answer that question, and particularly in a context where they will have their own thoughts, feelings and emotions about it, because we are human and that's natural. And I think one of the things that the children and young people involved in developing the toolkit really highlighted was how helpful it can be to have what they saw as a more neutral version of events, or at least a direct version of events from the person who made the decision, without any filter through any of the adults who've all got their own views about this situation, but from the person whose job it was to listen to the child and all the other information, take in all the other considerations that they have to have under the welfare checklist, to balance all of that up, to come to a conclusion, and that conclusion is going to influence that child's day-to-day life, probably for the whole of their childhood and with implications for the whole of their adult life as well. So the fact that as the judge you are uniquely placed to explain that to the person you're making the decision for, whether that's the adults or in this case the child, I think is a really powerful message from the toolkit. I think the toolkit goes a long way in supporting judges to think about how they might do that in a really successful way.
Play devil's advocate just for a moment.
Vacancy Legal Recruitment, a refreshingly unique and personal talent agency developed specifically for legal. Dedicated to the sector and with extensive experience working across legal services and legal technology, we bridge the gap between your requirements and top-tier legal talent. Get in touch today and say hello at vacancy.co.uk.
Is the judiciary appreciative, or is there any evidence that the judiciary is appreciative of what might come across as teaching grandmothers to suck eggs?
I think that was a real highlight actually of the toolkit being published. Was we agreed with the President's Office that as a sort of research body within family justice, we would be happy to collate any feedback that people wanted to share, because this is a new initiative. This isn't something that we as a justice system, or indeed we haven't seen a similar endeavour internationally. So we knew that this was going to be new, and you should expect feedback: good, bad, indifferent, mixed, all of it. So far, that which we have received has been really positive in terms of judges and other practitioners saying that they think it's a helpful and well-written document, that they think it gives, is pitched right in terms of giving practical advice without, as you say, David, teaching anybody to suck eggs. I suppose my understanding of the basis for it is that it was written in a vein that there are judges who do this very frequently. This is their day-to-day business, and they help to feed into the toolkit. We don't have any data on how frequently judges write to children. That's not something that's currently collected by the system. That's something that we as the NFJO would like to see improved within the data sets. But anecdotally, from the judiciary and other practitioners, we were told that that's still the minority practice, probably, for most judges rather than the majority. So it was really a case of saying, okay, well, if we've got some judges who feel really confident about doing this, how can we learn from them? How can we take the published examples, the not published examples? How can we draw together the learning from all of that and make it accessible to judges who might be feeling less confident about that? And that's actually in his foreword to the toolkit, something Sir Andrew Macfarlane talks about. He talks about the well-known inertia of a blank page. talks about how it's really hard to get started when you haven't done something before and you're not really sure where to start with it. And he also talks about judges being worried that about getting it right, understanding that children involved in family court proceedings have not had an easy time of things. By virtue of the fact that their family is in court, whether that's in public law or private law proceedings, things have gone wrong for them. And the judges involved in the development of the toolkit were very aware of that and very clear that that is a consideration, is saying, we want to make sure that we are getting this right. We don't want to make things worse. But that's why I think the input of children and young people, both from the summaries of the research that the toolkit includes and from the direct quotations of the Family Justice Young People's Board, they really highlight that saying nothing isn't getting it right. That actually leaving children to try and fill in the gaps themselves in a context where, as I've said, their family, the adult family members, might be having a really difficult time as well. They might have their own views and emotions. And so what the wider research talks about is a situation where children often know more than the adults around them realise, but they don't have the full picture. And in the context of those gaps in information, children try and come up with explanations for what's happened themselves. And those explanations can be quite inaccurate, as you might expect, when they're left guessing. And they can also be quite self-blaming. So children, particularly young children, their sense of the world is through their own lens. It's about themselves and what they understand about being their power in the world. And so they can quite easily fill the gap with, this must be my fault, I must have done something wrong. This is a real opportunity for judges to give enough information that children aren't put in that place where they have those sort of worrying conceptions. And that's what the young people in the toolkit talk about. There's sort of quotations at various points in the toolkit, as well as a forward from the Family Justice Young People's Board, where they talk about something being better than nothing. Understanding that judges are rightly worried about making things worse, but giving a really clear message that not doing anything is problematic in itself. And that I think it's really nice that the young people who are involved in creating this toolkit talk about hoping that it gives judges the confidence to do this. It's a really warm spirited forward that the Family Justice Young People's Board have written, as is the President's. It's a really positive forward looking approach to doing something practical to help judges do something that children and young people have said will make a difference for them.
I mean, 100%. The forward from Sir Andrew McFarlane says, I hope that this changes the culture of this process and encourages it to be more of a norm for judges. I guess, and again, perhaps with that devil's advocate hat on, I sit here and think to myself, caseloads are already overloaded. The judiciary is under a huge amount of pressure. They can read the guidance by all means. It's only a 7 or 8 page document, isn't it? But where have they got time to invest in doing this?
I think that is, that's the golden question, really, David. And I think, as I've said, I am conscious. I don't want to undo the work of the judges who are already doing this, of which I know some, and there are definitely some involved in the conversations about the creation of the toolkit. But also I think it's important to understand that the toolkit was developed in that context, with that background absolutely front and centre. That, as I've said, this is something that judges want to get right. They are conscious of the importance of getting it right. And that, as Sir Andrew said, that sense of starting from a blank page, if it's not something you do frequently, then it can feel like a very time-consuming thing to do. And that's some of the judges talking about it in the context of the development. The conversations that I was part of talked about saying, once you've done a few, you do get much quicker at it, because you get much more used to the style of how you communicate to children. But I also think it's worth bearing in mind that the purpose of Children Act proceedings in private and public law is to promote the welfare of children. That's what we're there for. That's what all the days in court, all the pages and pages of legal documentation, all the arguments, all the evidence, underpinning all of that is the purpose of the family justice system to promote the welfare of children. And what the research tells us is that children's experiences of proceedings have a relationship with their well-being. This isn't something, an adjunct to it. This isn't something that happens, separately to children's lives. What happens to them, for them in court, affects how they feel about the decision, and it affects how they move forwards with their lives. Judges, in doing that role of promoting the child's welfare, are constantly learning about the different things they need to think about the different things they need to do. And I think what's really emerged in recent years is that children as active participants in proceedings in ways that work for them, whether that's having letters written to them, whether that's meeting with judges, whether that's them writing to judges when they're meeting with CAFCAS, for example. There are all sorts of different ways, because all children are different, all children will want and need different things. But the real importance of that in terms of getting it right for children, given the strength of feeling from the young people involved in putting together this toolkit and the many and various bits of research that point in this direction, I think it is important to be thinking about where judges are going to find the time for this. But it's also important to think about what judicial time is used for and how we make sure we're using it in the best possible way to promote the welfare of children. So if we've got good evidence that this could be something that can make a real difference for children, then we need to be thinking about how we prioritise time for it. And I very much hope that, as I say, this is the guidance from the President to his judges. I very much hope that those are ongoing discussions within the judiciary, and I have a huge amount of sympathy for the judiciary and all of the practitioners across the family justice system in terms of the immense strain that the court system is under and that they're under, working with families at such difficult times in their lives as well. But I don't think as a system we can afford to say this is how we've always done it. So as long as we continue to do like we've always done it, and as long as we have time to do that, then that will be good enough, because we need to be a learning system. We need to be a family justice system for the 21st century that learns as it goes and says, okay, well, we've learned that one of the really important things for children in this whole process about them, we could have proceedings that go on for 3 months, we could have proceedings that go on for 2 years, but ultimately one of the things that's really important for them as they move on forwards with their life is understanding what happened in those proceedings, how they were heard and understood within those proceedings, what was decided and why. And we need to find ways of building that into our systems. And that's, not necessarily an easy task, but it's definitely a necessary one.
What's the sort of knock-on impact then for practitioners, for family lawyers from this guidance? What do you anticipate how do you anticipate they need to react to it or respond to it?
I am going to steal some words, I'm sure she won't mind, from a barrister called Anna Yard at Harcourt Chambers, who I saw when this was published, put on her LinkedIn that toolkits for judges are never just for judges, and that all advocates need to be able to contribute to discussions at court about children in proceedings, and that all advocates need to be confident in applying the right principles and techniques when asked to review a letter from a judge to a child, as she says, as I have been. So I think it is exactly as you said, David, if this is going to become part and parcel of the normal court's work, then it is to some extent part and parcel of advocates in court's work, and also for sort of solicitors in terms of preparing cases as well, because what you do not want, going back to your earlier point about pressure on judicial time, what you do not want is for everyone to suddenly remember that this is a thing just as everybody's preparing to leave court and the judge is about to start on their next case, and then you get into the business of trying to communicate what needs to happen through email. This is something that we need to be thinking about much earlier on in proceedings. We need to be having those conversations about whether a letter is going to be written, who's going to give the letter to the child, who's going to share the letter with the child, and to be having those conversations early enough that you don't end up in that kind of mad rushed situation on the final day of a final hearing, for example. That's going to be one where the judiciary, I would expect, will be looking to lawyers to support thinking about that in terms of things like position statements. I mean, absolutely, if lawyers are representing children, whether that's in private law or public law proceedings, but I'd say also if you're representing parents in private law proceedings or public law proceedings, this is a key element for lawyers to be thinking about in that context. The toolkit also talks about judges leaning on the professional network, and as Anna said in her commentary on LinkedIn about it, that might mean asking people to check a letter to say, can anyone see anything that's wrong with this? Partly because, going back to that language point, sometimes it's just really hard when you're writing to take a step back out of something that you've written. Sometimes it's just having another pair of eyes to say, actually, I'm not sure this 9-year-old child is going to understand the word that you've used in that context. So there is a suggestion in the toolkit that judges should be doing that, and that might be leaning on where you've got social workers and psychologists and other experts involved in the case. That might be leaning on those, but in many cases you won't have that kind of expertise. So I think that may well be a job where lawyers need to be thinking about that. And so I think, again, the toolkit's really helpful in setting out the why we would do this, which I think can help people feel confident in giving a view on whether or not it feels like that's in the right ballpark in terms of letters to children.
And I suppose there's an element of professionals expecting it as well, and seeing it through the lens in which it is delivered. So it's as important for them to read and understand this document as it is for the judiciary.
I think so, yes. And as you've said, it's a very accessible document. It's not particularly long. It's written, as you would hope, I think, in terms of when you're talking about letters to children being easy to understand, you would hope the guide on writing them would be easy to understand. So I think just being familiar with it as a lawyer so that you can have informed conversations about whether the judge says, do you think this is going to be suitable, being able to give a view on that, and also thinking as you're preparing your position statement, preparing for final hearings, thinking about when and where conversations might happen around this, and also being able to have those conversations with clients. As I've said, if you are representing parents, to be able to have the conversation with parents about why a judge might be doing this, why a judge might choose to write to their child. As I mentioned, one of the groups that fed into the development of the toolkit was the Family Forum, which is a group of parents and other adults with experience of the family justice system. And I think their input really flagged something which comes out from other research with parents in this context, which is that it can be really hard as a parent to know what you are and are not allowed to say to your child about proceedings, and to say it in a way, they've got the same concerns that the judges have got. They don't want to make it worse. They want this, they know that things are already really difficult for their children in these circumstances, and they are trying to do their best in that context. And this is a real opportunity, actually. Having a letter written from the judge can, in some cases, take the pressure off a bit in terms of providing that explanation, so that the parent doesn't have to think, okay, well, how do I go about explaining what a judge is to my child? Because actually I am the judge and this is what I have done is a bit of what the toolkit suggests judges might include in their letter. Just setting up the basics so that can give a bit of a starting point in terms of children's understanding.
Coming from somebody that, although is involved in the situation, is removed from perhaps the immediate family, would be really, really useful. I guess somebody that might be, in inverted commas, independent would provide a useful context for the letter as well. It's been great to have you on the podcast, Jude. You do not need to tell me the power of the written word. It's hugely powerful, and it remains so, and it's why publications like Today's Family Lawyer remain relevant and important, because people still place a lot of value in the power of the written word. So thank you for joining and sharing your expertise.
Thank you very much, David. And as I said, we as the Nuffield Family Justice Observatory are noted in the toolkit as a place for collecting feedback on this toolkit. So if you are a lawyer in practice seeing this being used, we really love to hear about it. And as I've said, if we're going to be a learning family justice system, that means hearing about the good and the bad, and thinking about how we use that information and feedback to continue to make the system that works better for children and their families. So please do, you can find our details in the toolkit, and we'd really like to hear from anybody who's got any experience of seeing this used in practice.
The Today's Family Lawyer podcast is available on your preferred podcast provider. It's also available on todaysfamilylawyer.co.uk. My thanks to Jude. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Family Lawyer podcast, the leading source of daily news and insight for family law practitioners in England and Wales. Sign up to our free weekly newsletter at todaysfamilylawyer.co.uk and subscribe to hear all the latest news and views from across the family law sector. You can also follow us on LinkedIn and Twitter.